My name's John Larkins. I'm to chair this particular presentation, Planning Traps for Property Lawyers. Could I ask for mobile phones to be turned off? In general terms, the format will be Tom Pikusa will give he'll commence with a general presentation in relation to planning. Tom's been a barrister for 10 years. His practice has a focus on areas of law involving architecture and the built environment, principally in planning and environmental law and property and construction law. Tom has a broad experience in a wide range of planning disputes, acting for objectors, councils, statutory authorities and developers. Tom's environmental experience includes advising on Commonwealth and state environmental and heritage issues, contaminated land, coal seam gas exploration and wind farms. In particular, in the climate change area, Tom has advised about the impacts of sea level rise on coastal development and in relation to carbon offsets and carbon farming. Tom's a key member of the Climate Change and Environmental Law panel at the Victorian Bar. Tom will be followed by Tiphanie Acreman, and there'll then be a short break and we'll finish with a presentation by Andrew Walker. So I commend the seminar to you and we'll start with Tom. Thanks, Tom.
Thanks, John. Welcome, everyone. I hope it wasn't too early a start for you. Certainly I had to de-ice the car before I came in this morning, so it's a bit of a novel thing in Melbourne at this time of the year, I suppose. What I thought I'd do this morning is just talk to you generally about a couple of key things about how the planning system works. Now, you probably all got a bit of an idea about how the system does work, but I just wanted to point out a few key things for you, just bearing in mind that as a property lawyer or a conveyancer, you need to have some idea how the planning system works and what things like planning permits mean, so at least you can give your clients some preliminary advice about what use or development they can have on the land, for example, if you're acting for a purchaser, once the settlement goes through. So I thought I'd just talk about a few general topics because I wasn't too sure at what level your state of knowledge was about planning issues. But just a few things about interpreting the planning certificate, which is something that you have to get for every Section 32 statement, but also making you aware of the fact that you can do planning searches online, which in an informal sense also helps to understand what the planning controls are on a bit of land. Briefly look at what the Planning and Environment Act is all about, and it's basically about controlling use and development and what that means. The key thing that you need to be aware of and may have to deal with to some degree is planning schemes, and I just want to give you some tips and tricks about how you go about looking at a planning scheme quickly and the kinds of things you might want to say to your clients about the use and development. And part of that process will be just looking at a couple of planning controls to give you a sense of what they are like, given they're all in pretty standard format these days. And finally, one of the things you should also do in addition to getting a planning certificate is check with the council to see what planning permits have been granted. And if you do that, there's just a few things that you need to look out for on a planning permit, and I've just got an example that we'll look at there too. So hopefully from this you'll be able to take away some key things that you need to do each time you're doing conveyance and there's some planning issues involved, to at least give your clients some preliminary advice. All right, so just looking at some very key planning issues, and the other guys this morning are once I've finished, going to talk about some more specific things to be aware of as well too. Planning legislation dictates how you use and develop land. Permits run with the land and they're not a personal right. So they're effectively like almost like a restrictive covenant in a way. And a lot of people have said over the years, the planning scheme when it came in the Planning Environment Act dates back to 1987. There was some controls in place before then, but effectively the planning scheme and this whole system of permits replaces the whole restrictive covenant process that operated on, still operates in lots of places in inner Melbourne. But if you think about it in the nature of being of a restrictive covenant, well, that gives you a fair idea of the controls that might apply to your land. And with that in mind, the key issues if you're acting for a purchaser of land that you have to ask include what does the purchaser want to do with the land after settlement? Is the existing use or development permitted anyway? And if they want to do something different to what's permitted at the moment, can they do that? Or do they need to get a permit for that, or do they need to change the existing permit? So some fairly important things. Obviously you start with, well, if you're acting for a purchaser, and I'll just assume that you are, the key thing to ask is, well, what do you want to do with the land afterwards? Now, fair enough, in the case of a residential purchase, presumably all they want to do is continue to use it for residential purposes, but they might have ideas of wanting to use the land for a home office or, some sort of mixed use or something like that, which is a lot more common these days than it used to be. And that's where it can get a little bit tricky, is with them saying, oh, well, that's what I want to do. To what extent are you able to say, well, okay, well, you can do that under the existing zoning controls or under the existing permit, or actually you might need to go and get a new permit for whatever activities you want to do there. I hope you can read that there. It's a bit hard putting these onto PowerPoints, but anyway, that's an example of a planning certificate. It's one that's relatively recently obtained, and it gives you some pretty basic information about the planning controls that apply to a piece of land. The address on that particular certificate was 45 to 47 Murray Esplanade, Echuca, and you get a lot in a plan reference. So first thing to do is just check you've got the right piece of land. Generally speaking by the address, but interestingly, for that property address, there's in fact three parcels of land. So you do need to check, well, this is the one for lot 2, but maybe lot 3 is the one that's of relevance in this case. So just check the address first and then your lot and plan reference to make sure you're on the right page. The certificate will tell you what planning scheme applies, and obviously for each council area there's a planning scheme. So there's 78 planning schemes in Victoria, and not surprisingly, if you're in the Campaspe Shire, as you are in Echuca, it's strangely called the Campaspe Planning Scheme. The zoning in this case is Business 1. There's a heritage overlay. There's an amendment. See, I don't know, you probably can't read that down the bottom there, but it says a proposal amending planning scheme C50 has been placed on public exhibition, which shows the property is within an additional heritage overlay. So I've just put there, Amendment C50 Heritage Overlay 35. Now that's something you'll see from time to time on certificates, and it is something you need to check. The significance of that little overlay in respect of this parcel of land is that rather than there just being a general sort of heritage consideration for things you're doing to the outside of the building, anything you do to the inside of the building under that overlay is something that you have to consider as well too and get a permit for. So that may or may not be significant, but it's certainly something that you need to advise your client about. I've certainly had situations over the years where you may recall a few years ago that the previous Labor government went around Melbourne and designated a whole lot of area on the outskirts green wedge zone. And a solicitor did their conveyance for a purchaser for what they thought was a nice little residential rural block, or a nice rural block on the outskirts of Melbourne that they wanted to put a house on. And the certificate said there's a planning scheme amendment that's going to change the zoning from rural living or something like that to green wedge zone. And the significance of that is that once that amendment went through, which was soon after settlement, you couldn't build houses on the property anymore, so the purchaser had bought a piece of land that they couldn't develop with a house on there. And naturally enough, they were pretty grumpy about that. So always look out for what amendments are there and try and work out whether they have any impact or not. I have to say, in inner city Melbourne at the moment, a lot of the amendments that are going through are area-wide heritage amendments. That seems to be in vogue at the moment, and there's lots of these planning scheme amendments on foot. I think there's about 8 or 10 going at the moment in the inner city council areas. So they generally have less impact on how you can develop land than something specific like this, but you always do need to check that. Okay. In addition to the certificate, which you obviously have to do as part of your Section 32, you can also do a planning search. And look, you just type into Google or Bing or whatever, planning maps online, and up will come planning schemes, dpcd.vic.gov.au. You can type in the property address and up will come a property report, which looks like this. It's free, and what I like about these is that you see the land in its context. You can see that this is 45 Murray Esplanade in Echuca. The land's always dotted in red, so you can see if you're talking about the right piece of land. You can then also see what zoning controls operate within the area. And the other good thing about it is that where it says under planning zone, it's got business 1 zone. If you click on that, it will take you to the actual provision in the planning scheme, which is very, very handy, I have to say. So when you're doing a conveyance and you're thinking about, well, what are the planning controls that apply? You need to get one of these searches done, which you can just do at your computer. Save that into the file, and then you've got references to all the planning scheme, zoning and overlay controls. Now, they're often about 3 or 4 pages, and I've just reproduced the first page there. So keep that in mind too. That's a very, very, very useful tool. Oh, and you can also get an app for your iPhone as well too, which allows you to do these searches, the property searches as well. Okay, so Planning and Environment Act, the key thing to know there, it's about use and development. The use is the most important aspect of the controls that the Planning and Environment Act has. Use the house as use the property as a dwelling, for commercial purposes, as a shop, for industry, whatever. That's what the use is about. Development doesn't actually give you approval to construct, but what it's about is if you're within an area and there's no issue with the use, but just a double check to ensure that how you're proposing to develop the land is consistent with all the provisions of the planning scheme, so like amenity issues and those kinds of things. So sometimes you might not need a permit for the use, but you would use a permit for the development. And you need to check the provisions of the zoning control and the overlay control to see what they are. Now, as I said before, each council has a planning scheme. The planning schemes are formally printed by ANSTAT, so they look like pieces of legislation, and each one's generally about 1,000 pages or so they're big, chunky things. If you go to that website that I mentioned before, Planning Schemes Online, every provision in the scheme is available for you to look at in PDF form, or you can download the entire document from there, and they're updated all the time. So, and that service seems to work very well, so you can get the most relevant up-to-date version of the planning scheme online without having to go and buy it, because I think they used to be about $150 a throw for each planning scheme, and then an amendment would come through and it's out of date again. So very good to know those things, but each planning scheme is set up in a standard way. So there's state policy at the front, and that covers things like housing development, economic development generally, environmental issues, a whole lot of broad brush things, climate change, all those sorts of things, and how that needs to be responded to, but on a very broad-based level. The next section in the scheme is council-specific policies about development and how things are going to go. The more specific controls that you'll probably be looking at from day to day are the zoning controls, which follow next. And what they mean is that every single parcel of land within the council area is zoned for a particular use. So the most common ones are housing, industrial, business zones, and there are different categories within there: business 1, 2, 3, residential 1, 2, 3, those sorts of things. All those zones are common across the state, and generally speaking, the zoning provision in a particular council is going to be the same in each state, although there might be a schedule that has some slight differences in there, but generally speaking, not much change between zones across the state, between planning schemes. Always pays to check though. The other control that you see in a planning scheme is something called overlay controls. And what an overlay control is, just take the city of Yarra for example. Most of Carlton and North Carlton has a heritage overlay that applies to that entire area. So it's another set of controls on use, but it's often on like an area basis rather than a site-specific basis. And they often, well, in the case of the one I just gave you, relate to heritage considerations that you need to have. Sometimes they're about height controls. So, for example, in most council areas that run along the Nepean Highway down on the foreshore in Melbourne, there's a 2-storey height control. And that's by way of something called a design and development overlay. Mysteriously named, but it's basically a height control. Towards the back of each scheme, and this is common to every scheme now, there are a series of specific provisions that relate to particular activities or cover things like amenity considerations. You know, how close you can build your house to the neighbour next door without overshadowing them, without building too much on the boundary, those kinds of issues. And there are also controls for things like bushfire areas or particular things like, you know, how Telstra can put a telecommunications facility, you know, mobile phone tower in your area, that sort of thing. And at the very back then there's some interpretation provisions and some general provisions in there which say, regardless of what the scheme says in the front, you actually don't need a permit in certain circumstances. All right, now this might be a bit tricky to read, but I'll sort of guide you through it. This is an extract of the Campaspe planning scheme for the Business 1 zone. So remember that certificate I got earlier, Business 1 zone. If you click on the link from your planning search, this is what will pop up, a short 4-pager, or 6-pager in this case. The key thing to look at first is what they call a table of uses. And there are 3 types of uses. There's Section 1, Section 2, Section 3. Section 1 is as-of-right uses, which generally speaking means you don't need to get a permit for those particular uses. Section 2 are permitted uses, but you do need to get a permit. And Section 3 are prohibited. You can't get a permit. You can't go to VCAT and get a permit either, it's prohibited. So what you see there is part of the Section 1 table, and on the left-hand side are a whole lot of uses that are identified, and they're all defined uses. And if a lot of the time they have a relatively straightforward meaning, but you might need to look at the interpretation provisions that are at the back of the scheme to work out what some of these things are. A postal agency, what railway means, that sort of thing. And once you've done that, you then need to look at the left or the right-hand side to see if there are any particular conditions that need to be satisfied. So if you fall within the use definition and you satisfy any condition, in the case of Section 1, you don't need to get a permit. Same applies for Section 2, or there might be some additional conditions that you need to comply with as well. And obviously for Section 3 prohibited, you can't do any of those activities in that zone. Now looking further on, after you pass your table of uses, the other general thing in the same way there's policy that generally informs how a decision is made, the other thing to look at is there's purposes in each zone as well too. And they can help inform you of what may or may not be available to be undertaken in a particular area. The other thing that is useful to know is that each provision then goes on to say, okay, well look, if you do need a permit for a particular use, this is the information that you're going to have to prepare, and these are the considerations the council office is going to have when they're making a decision. The other thing to look at is that there's always a provision about buildings and works, and that will say, look, if the use is not an issue, you might still need a permit for what you're proposing to construct on there. And there's often some a general provision that says you'll need a permit for buildings and works, except in the following situations. So there's a whole lot of exemptions within, generally speaking, each zone about that, so you should have a look at that too. With a heritage overlay, and I'm sorry you can't read these, but similar sorts of things, although given that it's not really a question of use, it's a question of actually being in a particular area where the overlay applies. The purposes are something that is important to have a look at. In the case of heritage, is the development going to affect the heritage significance of the place, whatever that might be. And the thing about an overlay control is that you might not need a permit under the zoning control, but you might still need a permit under the heritage overlay. And it's generally for buildings and works. So you might be free under the use or the zoning control, but you might still need to get a permit under the overlay control. So that's why you've got to have a look at both. All right. And again, look, there's just provisions in there which say you might not need a permit in certain circumstances. And the other interesting thing in an overlay control is that they have a provision about the giving of notice. And in a lot of cases, like for example in the heritage overlay, you generally speaking don't need to give notice to other parties of the fact that you're applying for a permit in the heritage overlay, and that obviously has significance because there are no third-party appeal rights that accrue as a result of needing to get a permit under a heritage overlay. All you need to do is deal with the council in those circumstances. So hopefully that might avoid the need of a party to go to VCAT. And that's obviously quite a significant thing because going to VCAT might slow up a project by a year or something like that. Now, I'll just quickly look at permits. I think I'm probably running a bit over here. They run with the land, look at the permitted use, get a copy of the endorsed plans, and have a look through the conditions to see if there's anything particular there that you might cause a problem. So, briefly, this is what a planning permit will look like. Address of the land is at the top. You'll generally not see any lot or plan references there. It'll just be an address. What will the permit allow? That's your permitted use. Have a look through that and make sure that the purchaser or your client falls within that permitted use. And then read through the conditions. At the bottom of that page, there's a condition that says the use can only occur between certain times of the day, and it can only involve a certain number of people coming to the site. That may or may not be significant to what your client wants to do. The other thing is the permit condition at the end, which talks about when the permit starts and when it expires. Because it may well be something that the permit has been granted for the land but not acted upon, and you might therefore need to go and get a new permit for that particular activity. And the only thing to bear in mind there is that the planning scheme might have changed and you can't get a permit for that anymore. So, just some key points about permits. What's permitted use? Has it been acted upon? was it acted upon within time? Any conditions that might restrict the ongoing use? Are there endorsed plans? Now, don't forget as well that you might have a permit for the development, but that actually doesn't allow you to construct the building. You need to get a building permit too. So don't forget that too. Don't mistake a planning permit as allowing the development to proceed. It does, but you still need a building permit to actually construct it. Good day, thanks very much.
Thanks very much, Tom. You did go over time, despite promises to the contrary, but we've done okay. What we tried to do when we were planning this particular presentation was go sort of from the general to the particular. Just a couple of housekeeping matters. All slides and handouts will be emailed to registrants after the event. So the fact that you can't read something up there can be addressed later. And there'll also be an opportunity, if we have time, for some panel discussion and questions at the end. So just in going perhaps more to the particular, we'll go to Tiffany's presentation. As I said, it's Tiphanie Acreman. Tiffany principally appears and advises in planning, property and commercial matters. Prior to coming to the bar, she was an associate to the Honourable Chief Justice Warren of the Supreme Court and later to the Honourable Justice Judd of the Commercial Court. She holds a Bachelor of Laws with first-class honours and a Bachelor of Science, majoring in Geography and Environmental Studies. On her CV is a recent appearance in Healthscope Limited and the Moreland City Council and others, which was a red dot VCAT decision where she was successful in arguing that a proposed expansion of the John Faulkner Hospital contravened a restrictive covenant and therefore a planning permit could not be issued. Tiffany's going to talk about bushfire risk and the impacts of climate change. So over to you, Tiffany.
So I will be speaking about two issues. And they're issues that, if you were to look at a planning property report, wouldn't necessarily be obvious, and they're issues that prevent you getting a permit, sometimes even where land is zoned for development. Firstly, I'll be speaking about the bushfire management overlay, and in particular the transitional provisions, because VCAT has some interesting decisions coming out at the moment about the extent of the application of the transitional provisions, and it seems that the application of those provisions is shrinking. I don't have any PowerPoints to show you at the moment, but don't fear, they will be emailed to you tomorrow or early next week, along with the other slides. I will be referring to cases and I won't be giving you the references. They'll be in the slides, so don't worry too much. I just think it slows everything down and I want to get on with it. So the bushfire management overlay replaced the wildfire management overlay on the 18th of November 2011. And it is an overlay, so it will show up on the planning report that Tom mentioned. In relation to the transitional provisions, in fairness to people who already had applications on foot on the 18th of November 2011 when this came in, the bushfire management overlay provides as follows. The requirements of the wildfire management overlay of the scheme in force immediately before 18th of November 2011 continue to apply to any planning permit application lodged before that date. So if you had an application on foot at the 18th of November 2011, then the wildfire management overlay provisions still apply. They're less stringent than the bushfire management overlay. And so it will be a little bit easier to get a permit for your dwelling in a bushfire-prone area. So it is critical in some cases that you get the tribunal to agree with you that the wildfire management overlay applies. Now, the bushfire management overlay and the more stringent provisions came in following the 2009 Bushfires Royal Commission. The first case that really looked at these issues that came out of VCAT was land management surveys, and in that case, the tribunal stated that the Black Saturday bushfires and the Royal Commission have been game changers. Everything changes from now on because of what happened in Victoria in February 2009. There may be some parts of Victoria that are so bushfire prone that even with a raft of permit conditions, facilitating more intense human activity is a poor planning outcome. So there are some areas where you simply can't build anymore and you can't impose conditions that will improve safety to a level that's acceptable in a planning sense. And this is actually stated in the bushfire management overlay, which says that development is not to proceed unless the risk to life and property can be reduced to an acceptable level. So if your permit conditions can't do that, you can't build. And there are cases where people have been refused changes to their permits or a permit to build a dwelling in bushfire-prone areas. And I'll look at some of those now. Marsden and Macedon Ranges Shire Council demonstrates that the transitional provisions within the bushfire management overlay don't apply to amendments to existing permits where the permit was issued before the bushfire management overlay came in November 2011, but the amendment was lodged afterwards. So Marsden had a permit. It was issued before November 2011, and then he applied for changes to that permit. It was actually for a school, and he wanted to increase the capacity for students from 100 to 196. The tribunal found that the transitional provisions, which allow you to use the wildfire management overlay as the assessment method, only applies to permit applications that were unresolved as at the 18th of November 2011. So you can't get around the bushfire management overlay by saying, well, although I want to amend my permit, I applied for it before the 18th of November 2011. It is only unresolved applications at the 18th of November 2011 that will attract the transitional provisions. The second case I'd like to look at is Kennedy and Cardinia Shire Council. Now this case, it was a practice day case, so it's quite brief. It's worth a quick read. Basically, from this case, we know that even if you have an unresolved permit application as at the 18th of November 2011, if you then try and amend that application, you'll lose the benefit of the transitional provisions. So Kennedy took the principle in Marsden even further. They were handed down at around the same time, but they demonstrate that the tribunal is applying the transitional provisions very narrowly and is basically saying it's the bushfire management overlay now. No, you can't use some loopholes to get back to the wildfire management overlay. The most surprising decision has come out recently. It was handed down on the 26th of April 2013. This is Estate of Mabel Watson, and it's a red dot decision. It goes even further than Kennedy and Marsden, and it says that even where the transitional provisions do apply, so you had a current permit application on foot as at the 18th of November 2011, and so therefore the wildfire management overlay provisions apply. Even where you get to use the wildfire management overlay, some of the mandatory requirements in the bushfire management overlay are appropriately considered under the wildfire management overlay. So effectively, what's happening is that the tribunal is saying current knowledge about bushfire management can appropriately be and should appropriately be incorporated even where you are being assessed under the old provisions. So that's extended the scope of the bushfire management overlay and shrunk the scope of the transitional provisions significantly. So, in particular, in this case, there are some mandatory provisions in clause 52.47 that need to be taken into account when being assessed under the bushfire management overlay. The locational provisions in particular, in this case, were relevant. So the location objective is to ensure that development is located and sited so that it doesn't increase the risk to life, property and community infrastructure from bushfire. And there's a standard incorporated that development should avoid locations where the risk to life, property and community infrastructure from bushfire cannot be reduced to an acceptable level through bushfire protection measures. So in looking at those, the objective and the standard, there are a number of decision guidelines also incorporated. They're mandatory in the bushfire management overlay, but they'll apply when being assessed under the wildfire management overlay through clause 65 of the planning scheme. And the tribunal said that clause 65 allows these matters to be taken into account. It doesn't make them mandatory, they're discretionary, but the issues need to be understood and dealt with in light of current knowledge. And understanding about fire hazard, fire behaviour and fire protection is an evolving science. And therefore, even though the wildfire management overlay was introduced some years ago, it needs to be assessed in light of current scientific knowledge, which makes perfect sense, really. Unfortunately for permit applicants, they can't know what the current science is unless they investigate it at the time they're making their application. But to ignore the current knowledge about bushfire risk is really anathema to the findings of the Royal Commission in my submission. I'll move to coastal management now. In particular, the coastal management strategy and how that's incorporated into planning schemes. And again, the inclusion of the principles that are embodied in the coastal management strategy means that sometimes, even where you are applying for a permit for, say, a dwelling in a township zone, which encourages residential development, you may not be able to build on your block of land. And obviously that has quite significant consequences for clients. I'll give a small potted history. So in 2002, the coastal management strategy was introduced, and this is the old strategy, it's not in force now. The focus of that strategy was on the effect of development on the coastal environment. So if we build on a sand dune, will we be destroying it? Now, with this new 2008 strategy, the focus is on the effect of the environment on coastal development. So if I build a house, will sea level rise mean that erosion undermines the footings and the land is inundated? So the focus has flipped around significantly. The coastal management strategy that was introduced in 2008 incorporates a couple of things. It requires decision makers to apply the precautionary principle, and it also incorporates benchmarks required to be incorporated, benchmarks for expected sea level rise. They initially were just a straight 80 centimetres by 2,100. In July 2012, they were rolled back in some areas. I won't get into the detail of that. The 80 centimetres by 2,100 applies generally, except for some, except for in some instances. And the effect of this strategy on permit applications is certainly not obvious from the planning property report that Tom mentioned. So it's just an additional factor that you need to be aware of. Prior to the 2008 strategy coming into force, there was a landmark decision in VCAT that indicated that the tribunal was moving towards applying these principles anyway. And in doing so, the tribunal noted that they didn't have proper guidance and that guidance was necessary for how these principles would be applied in future. So the 2008 strategy has now provided that guidance. So the case is Gippsland Coastal Board and South Gippsland. The 2002 strategy was in place at the time, and that strategy made no mention of the precautionary principle, no mention of benchmarks for sea level rise. It was an application for 6 allotments, for dwellings on 6 allotments, and the allotments had been created in the 1890s, and they were zoned as in the farming zone. The tribunal actually rejected the permit application on a number of grounds, but that included climate change grounds. It determined that sea level rise and the risk of coastal inundation are relevant matters to consider in appropriate circumstances, that it should apply the precautionary principle when assessing these matters, and that applying the precautionary principle and looking at storm surge events and sea level rise, a reasonably foreseeable risk of inundation of the land in question existed, and that this was an unacceptable planning outcome. Now, the tribunal has handed down a number of cases subsequent, and some of these deal with other parts of the 2008 coastal strategy, which I simply haven't had time to go through with you. One of them is the requirement for coastal vulnerability hazard assessments to be undertaken, and these need to be prepared by a suitably qualified person. So effectively, in many instances where you're applying for a permit in a coastal area, you'll now need to get expert evidence in the form of a CVHA. Just quickly, in Myers and South Gippsland Shire Council number 2, the tribunal had, in the first case in that series, determined that a CVHA was required. It was an application to subdivide land into 2 lots, and it was actually in a township zone, so it was zoned for residential development. You would expect that you would be able to subdivide there. But the application was rejected on the basis that the expert evidence contained in the CVHA and provided at the tribunal was that without mitigation measures, the land would end up being inundated. So the subdivision was not approved. In Raunchy, the applicant applied for 2 two-storey dwellings on coastal land, and that was rejected. It was actually rejected on neighbourhood character grounds, but what the tribunal said was that for any future proposal, a CVHA would be required. And the practical effect of this is that with a CVHA, they were probably going to have adverse expert evidence and therefore wouldn't be able to get a permit, even if they amended their plans to so that the development conformed with neighbourhood character guidelines. So the property value must have taken a hit. I imagine that the client wasn't very happy. And the final case is TAPE. This was where the council issued a permit to develop 8 dwellings in the Business 1 zone. And it went to the tribunal, and VCAT sent a strong message to councils that they can't ignore this 2008 coastal climate policy. They stated that there's a planning policy imperative to act now rather than later. So council had argued that the application to construct 8 dwellings in the commercial area of Lakes Entrance should be approved, and that the coastal policy wasn't intended to stymie development in Lakes Entrance. And if it did so, that would amount to staged retreat, because this was in the commercial area of Lakes Entrance. And that sort of development is appropriate, according to council, in that area. And we would all think probably that it was in the commercial area to construct a development like that. They also argued that sufficient time was available before the full impacts of climate change were realised, and that they could develop policy along the way to deal with that. VCAT rejected these arguments and said, act now. You haven't got a policy, you need one. And you've failed to respond to the changes in policy that the state government has introduced and the obvious direction that this is going in. And to grant a permit without any policy about how you're going to deal with climate change in Lakes Entrance would be an unacceptable planning outcome in this instance. So the tribunal basically said, in line with the precautionary principle, it's not appropriate to pass on the burden of climate change and dealing with the impacts of climate change on development to future generations. You need to deal with it at the permit stage, not after it's been built, and then decide what to do about it. And that's all I need to enlighten you with.